Time to you, Paul Mazza. Paul is a partner in the firm of Mazza and Mazza with law offices in Hamilton and Toronto. Paul is the current editor of What's New and Wonderful for the Ontario Canadian Bar Association Real Property section. He's a past lecturer for the Law Society on powers of sale in Hamilton, Windsor, and St. Catharines. He's going to speak to you this afternoon on the topic of other and competing claims.
Thanks. Thank you, Carol. What we're really concerned with here are priorities, and what we're trying to do is save our client money. If you overpay on some of these items that I'm going to cover, you will find that you will be accountable to the mortgagor and subsequent encumbrances, and if you've made certain payments that you should not have been made, then the money will more than likely come out of our own pockets. Lastly, if it's an MICC or CMHC insured loan, your client will not be reimbursed for overpayments of, say, utilities and other items that I'm going to refer to. First of all, realty taxes, obviously, they take priority over a mortgagee selling under par of sale. The section referred to in the notes is 511. That's for RSO 1970. The pertinent section for RSO 1980, would you kindly amend it to read section 369? The business taxes are personal and do not take priority over the mortgage. On many occasions, I have run into local municipalities adding these to the tax rolls. Now, I must confess that I can find nowhere in the Assessment Act where the municipality has a right to add them. They do so, and unless you're very alert, you can find yourself paying or overpaying on what you thought are realty taxes, but in fact have been lumped together, business taxes lumped together with realty taxes. The housing improvement loan added to the tax rolls. You have to be careful here. Where a loan is given under the Housing Development Act, it's been held in Jones versus Gomez at page H3 that such lien, although it may be added to the taxes, does not take priority over a mortgagee. You must contrast this decision with Scarborough versus City of Toronto, where that decision involved different legislation. It involved the City of Toronto Act, and Toronto passed a bylaw for providing standards for dwellings and for directing the owners of dwellings to take the necessary actions to bring the dwellings up to standard. Monies were advanced. The key difference in the legislation was that such amount shall deem to be taxes. Mr. Justice Pinnell held that the lien in favor of the city had priority over the mortgage and bound the lands even though the purchaser took title from the mortgage without actual notice of the lien. How do you practically go about removing these loans from the tax rolls if you fall within the Jones versus Gomez decision? It's been our practice to forward to the legal department for the local municipality a copy of the offer, a copy of the statement of adjustments, and a copy of any appraisals that we might have, as well as a statement of accounting of the proceeds of the sale showing a deficiency. They in turn will remove the lien from the tax rolls. Unfortunately, it's a 2 to 3 month procedure, and the only thing that you can do in such a situation is to take an undertaking, and I know we don't like to take undertakings, but I just don't know of any other way in which you can force a vendor mortgagee to withhold monies when he can provide to you the decision of Jones versus Gomez clearly indicating that it does not take priority over the mortgage. As it relates, the next topic is condominium arrears. Clearly, prior to January 1st, 1978, such arrears never take priority. After January 1st, 1978, there is a lien which has priority over the mortgage to the extent of securing 3 months of arrears prior to the registration of the lien and all future arrears. The example is there on page H7. I won't go over it. Some people would question me and not agree with me in my example. There are no common element expenses that have been paid from June 1st, 1980 A valid notice of lien is registered on April 10th, 1981. For what period does the claim of lien have priority? The lien has priority for the following months: January 81, February, March, and April of 81, and all future arrears. Some of my colleagues would indicate that the priority would only be for February, March, and April. That's not the way I read Section 32.4 and 33.5 of the Condominium Act. Also, I should point out to you that the section related to registering a notice of lien, Section 33.5, relates to residential liens. If you have a commercial condominium, and there are not that many, it's governed by Section 32, subsection 5, and it says that the corporation must register a notice of lien within 3 months after default occurred, or you have lost your special statutory lien. Hydro arrears. Syncab Credit Corporation in 1978 decision held that a mortgagee in possession of premises extending from power of sale or foreclosure was entitled to a supply of public utilities despite unpaid arrears owing by the owner. The court held the mortgagee occupies in its own right and cannot be compelled directly or indirectly to pay the debts of the owner. After some vigorous lobbying, the legislation was amended on June 29, 79, and unfortunately, it nullified the previous decisions. In effect, Section 30, subsection 1, gives public utilities a statutory lien for a period not exceeding 3 months in priority to a mortgagee's interest, and such lien may be added to the tax rolls and are to be treated in the same manner and to the same extent as municipal taxes. Now, a lot of people quote to me the Power Corporation Act, and there is a conflict. Section 74 of that latter act states that where the Commission supplies or distributes power directly to the consumer, either on its own behalf or by arrangement or under contract, the amount payable by the owner is a lien and charge upon the building in the same manner and to the same extent as municipal taxes. But when a mortgage or lease of the building in question has been duly registered before an entry upon the collector's roll, the lien and charge hereby created rank after advances actually made under such mortgage. It's worth noting, as I point out in the notes, that all the recent decisions have been decided under the Public Utilities Act and have not referred to that act, and it's my suggestion that the Public Utilities Act will prevail over the Power Corporation Act. It might be interesting to note that when you act on a large commercial loan, and I stress that, should we not be searching utility arrears, as now we have noticed that they will take priority for a period of 3 months. We recently acted on a large commercial refinance and did such a search with the local municipality and found out that for the month of August, the hydro arrears were $7,000. So I suggest to you that maybe it's just another search that we have to do as solicitors to ensure that our client has priority over the utilities, at least for the extent, at least up to the time that we register the mortgage. Gas account arrears, in my opinion, do not take priority over a mortgagee's interest. The local gas companies do not come within any of the categories as established by Section 31 of the Act, and I've listed them there for you. In fact, gas companies are governed by Part 4 of the Public Utilities Act, and Section 49 reads that this Part 4 applies to all municipal or other corporations owning or operating public utilities. And lastly, there is no mechanism by which the gas companies can collect arrears by adding to the tax rolls as permitted under the Municipal Act for hydro arrears. Now, the section under metered water arrears, for some reason, a paragraph was left out in my typing, and I'm not satisfied with it, and you may wish to make some notes to clarify that section. First of all, generally speaking, there are two kinds of metered water arrears. There are arrears that are ongoing, and there are arrears that could occur for capital costs, especially when there's a new subdivision. The section related to capital cost is not 36221 of the Municipal Act, but Section 218, subsection 21 of the Municipal Act for RSO 1980. And it clearly establishes that those capital costs will have priority over a mortgage for the full amount. Now, for the ongoing arrears, we have to go back to Section 30 of the Public Utilities Act, where the municipalities will have priority for 3 months, with the following exception. You must check with your local municipality to find out, to read their legislation and find out if they are in charge of the supply of water. For example, in Hamilton-Wentworth, they're governed under the Regional Municipality of Hamilton-Wentworth Act. And at page H12 of the notes, it refers to Section 76 and 77, which is now Section 96, subsection 14 of RSO 1980. And in effect, and I don't know why this has occurred, but they have brought themselves outside of Section 30, subsection 1, and consequently, any arrears in that jurisdiction do not take priority over the mortgage for any amount. And I would suggest to you that you check each of your governing legislations as best as I could find in the Toronto area that you're governed under the Public Utilities Act. Now, liens under the Mechanics Lien Act. Needless to say that we have all read a number of decisions going both ways on this. I can only stress that you proceed, whether acting for a vendor or purchaser, with extreme caution. The relevant questions that you should be asking yourself are set out at page H13 and H14, primarily being, was it a prior or subsequent mortgage? At the bottom of page H14, the sections quoted to you are RSO 1970. They should be changed to read RSO 1980, and sections 7, 3, 4, and 5 are now sections 8, subsection 3, 4, and 5, and section 14.1 is now section 15.1. And these sections provide for certain situations where a mortgagee may lose its priority even though the mortgage had been registered prior to the registration of the claim for lien. If it is a prior mortgage, and a prior mortgage has been defined as a mortgage registered before the first work was done or the first materials placed or furnished. If a mortgage was registered in advance before any work was done, the mortgage would have priority over the liens only to the extent of the actual value of the land before the first lien arose. So if we look at the example given, a mortgage is registered on vacant land for $200,000, and in fact the $200,000 is advanced. At that time, no work has been done nor material supplied to the lands. Now assume that the value of the vacant land at the time the mortgage was registered in advance was $250,000. Suppose that a year later, when the work was first started, the land depreciated in value and its worth is only $150,000, and liens are subsequently registered. The mortgagee under these circumstances would have priority to the liens to the extent of only $150,000 being the actual value of the land at the time the first lien arose. Now, if the mortgage was registered after work had commenced, of course the mortgage would then be defined as a subsequent mortgage under section 15, subsection 1. And a mortgagee would have priority over all advances made by it before he receives notice in writing of the lien or before registration of a claim for lien. So in effect, a building mortgage can be in a better position than which would be a subsequent mortgage, than a prior mortgage. And that, in fact, has been established by the Porcupine Concrete decision. Now, what are the practical resolutions of this problem when acting for a vendor mortgagee and when you're acting on a purchase where a lien is registered subsequent to the mortgage? Well, firstly, when we note that there is a lien on title, we immediately provide to the lien claimant a statement from the mortgagee showing the amount of monies advanced under the mortgage, copies of the canceled checks of the mortgagee making the advances, the date the advances were made, copies of the appraisal without prejudice obtained by the mortgagee at the time of the advance, and any other pertinent information requested by the lien claimant solicitor. Of course, what we're trying to establish is that we are a prior mortgage, or in fact that the lien claimant has no right to claim priority. And we want to provide them with as much information and as soon as possible so that they can make their assessment, so that they can get back to us to say that we are not claiming priority. If we can establish that, then we will have a valid answer to a purchaser who requisitions a discharge of that lien. I contend that a mechanic's lien claimant who fails to provide an answer within a reasonable time after being apprised of the situation does expose themselves to costs should there be a delay in closing of the sale. And there is some authority for it. Alumix Industries is quoted at page H17. If we cannot get an answer, and there are cases that go both ways, and I've set them out for you at H17 and H18, then I think that a purchaser should do one of two things. Number one, have the mortgagee pay for the lien and the cost of the lien into court and have an order registered removing the lien from title, as occurred in P. Michaud Roofing. Or in the alternative, have a vendors and purchasers application. And I don't say this in the notes, but it's compulsory that you make the mechanic's lien claimant a party to that vendors and purchasers application, because as we are all aware, the order under the Vendors and Purchasers Act only binds parties who are parties to the application. And the Vendors and Purchasers Act, there are sections that permit you to add parties who would be affected by the decision. And there you would get a decision, hopefully, that there would be no priority of the lien claimant, and therefore could complete your sale based on the order. Notice of security, interest registered subsequent to the mortgage. This one is rather surprising, and the PPSA is really a nightmare. And so often you can get caught under this act, especially in a situation where I've seen foreclosures where they've served, say, the Union Gas, who have registered a security interest where the mortgagor has bought a new furnace or a new water heater, and the foreclosure shows Union Gas as the defendant, and they've been foreclosed and debarred, and that order gets registered on title, and everybody thinks it's A-OK. You must concern yourself with Section 36 of the Personal Property Security Act, and it's my opinion that depending upon which section you fall within, that security interest does not automatically get removed from title. And I'm hoping that I'm making it clear to everyone here that when there's a feeling that when you buy under power of sale, and if the power of sale is conducted correctly, then you don't have to worry about anything subsequent, or any apparent subsequent encumbrances. And what I'm trying to convey to you is that it's not necessarily the case. This notice of security interest could be registered subsequent to the mortgage and have priority. Utilities can have priority. Mechanics liens could have priority, even though they've been served and are subsequent to the mortgage. Getting back to Section 36, a security interest that is attached to goods before they become fixtures has priority over a mortgage of the real property to which the goods have subsequently become affixed. And that's in Section 36(1). However, in the case of a mortgage made after the goods have become fixtures, or in the case of advances made after the goods had become fixtures without actual notice of the security interest, the security interest would be subordinate to the interest of the mortgagee. And that's Section 36, subsection 3. It might be clearer if I go through the examples at page H22. A mortgagee registers his mortgage and advances the funds to the mortgagor. The mortgagor then purchases a gas furnace under a conditional sales contract, and a notice of security interest is registered on title subsequent to the mortgage. The mortgage goes into default, or mortgagor goes into default, and the mortgagee commences power of sale. In this situation, the gas company has priority over the mortgage, whether or not the notice of security interest was registered on title. The second example, the mortgagor purchases a gas furnace under a conditional sales contract and no notice of security interest, and a notice of security interest is not registered on title. Mortgagee registers a mortgage and advances the funds. The mortgagor goes into default and the power of sale is commenced. In this case, the mortgagee will have priority over the gas furnace, as the gas company should have registered a notice of security interest. And the notice provisions for registering are set out in Section 54, subsection 1. Now, I want to point out one other decision that you may find rather interesting, and it's a case that has been reported in the last 2 weeks in the All Canada Weekly Summaries. It's called Urman, U-R-M-A-N. Unfortunately, I don't have the citation, but I recommend to everyone to order the decision. And if I can give the facts to you and try to follow carefully, because it's a decision that's rather shocking. First of all, Mr. Urman was a mortgage broker, and he borrowed money from a bank to buy and sell mortgages. The bank registered under the PPSA, taking an assignment of his receivables. Crindell bought or took an assignment of mortgage from took an assignment of a mortgage owned by Urman and registered a valid assignment on title. The bank was not aware of Crindell's assignment, and Crindell was not aware of the bank's financing statement. Mr. Urman goes bankrupt. As between Crindell and the bank, the court held, Justice Steele, that Crindell's mortgage had priority over the bank, as the bank, by its actions, were deemed to have waived its security. And that's not so important, because if you get into the facts, there's evidence to show the bank waived its security. But more important, as between Crindell and the trustee in bankruptcy, the trustee in bankruptcy took priority over Crindell. The court held that the assignment of mortgage fell within the auspices of the PPSA, that Section 68 of the PPSA takes priority over all other acts except the Consumer Protection Act. As Crindell did not register under the PPSA, the trustee in bankruptcy took priority over the mortgage. The case is presently under appeal. It's caused a great deal of consternation, but you can realize the difficulties. You may be power sailing under your client who has purchased the mortgage or has taken an assignment of mortgage, and we are not aware, or maybe we are now aware, to register a financing statement when we do act on an assignment of mortgage. And if one is not registered, the trustee in bankruptcy will rank in priority. Okay. That's all I have.
Thank you, Paul. The next two papers have been included to deal with the problem of the conveyancing questions that arise when a mortgagee exercises a power of sale. The first paper is given by Martin Stambler, who gave a paper earlier today. I need not go into his curriculum vitae again. And Martin is going to deal with the problems leading up to the sale. And Martin, if you could...
I think this is the area that we're all really keen about. It's kind of by contrast. We have all this technicality and all the strictures of the legislation and the interpretation of it, very technical, and it leads you up to the point where you can sell and then dumps you. You're on your own as the conduct of the sale and how you go about disposing of the property. We're back to the common law and to the decisions, and unfortunately I'm going to have to go through some of them with you to indicate just where we stand right now, at least how I read it. If I was to ask the bottom line and say, don't discuss it, just tell us what is the situation with the standard of conduct for a mortgagee, I'd have to say to you, I don't know. So I'll go through it, and I'll pass for the moment on the start of the conduct of sale and start off with something just before you start conducting yourself to sell. You know, Lee Iacocca said a few weeks ago there was 3 things that were bothering the auto industry, and that was interest, interest, and interest. And I think if I say to you, what are the 3 things the mortgagee should do before he starts to sell, I'd say appraisal evidence, appraisal evidence, appraisal evidence. There are many lawyers who say, well, we expose it on the market and we know about what it's worth, my client knows what it's worth. You start reading these cases and see how they're starting to challenge the propriety of the sale. You need to know what you're selling. It just stands to common sense that if you're a vendor or a merchant, you've got to know the value of what you're selling. How can you possibly sell something without knowing its value? The question then is, get the appraisal evidence. What kind of appraisal evidence? I've mentioned in the material how to select an appraiser, what they mean, and I'll leave you to read that. But it's so often the practice to just write away to an appraiser and say, give me an appraisal. It's just not good enough. Proper appraisal evidence is obtained by engaging an appraiser with a letter of engagement, or having the appraiser give you a letter of engagement which will tell you, in which you will ask him what you want. Now, what you want is not an appraisal in the air. Also, you don't want an appraisal of fair market value. Otherwise, you're going to get an appraisal of fair market value based on the willing purchaser and a willing vendor given a reasonable amount of time to sell the property, and that isn't the case. It's a forced sale. And you can ask the appraiser, give me an appraisal based on a forced sale. That's one way of expressing it. You can have the appraiser give it to you based on a 30-day sale. That's sort of, if you're going to have an auction, you're going to sell it in 30 days, what would be the value, fair market value, based on 30-day sale? If you're going to list it on the open market, multiple listing, which is 3 months, you'll say, what is the appraised value, fair market value, based on a 3-month sale? So that they can value the property with that kind of focus. It's extremely important to give the appraiser all the information you can give about the property. Look at the title report. Is there any defects? Are there rights of way? All these things that it may be subject to, he's got to put in his appraisal and consider that in terms of value. If you don't tell him anything, he's going to assume they just don't exist. And then you've got an inflated appraiser that works against you. So that you've got to give him everything you can. He's got to look at that property and look at it carefully with comparables and the investigation he should. There have been cases, a couple of cases I cited, where appraisers have been held negligent because they just did a window type appraisal, didn't call up and call up the municipality, didn't make the investigations they should as to what the property was subject to. So zoning, all the rest of it, give it to him. Now, when you get that appraisal back, look at it and see what assumptions he's making, because he'll list those qualifications, and they love to qualify the whole appraisal so it really means nothing. I think I've quoted one of the qualifications to say, we take no responsibility for your information obtained from other sources. And they don't tell you what information they obtained from other sources. So that, all the appraiser could be hearsay. And you don't know. You've got to pin him down and say, what are you doing? Because he could have done his appraisal based on a database of what's in the multiple listing service and never really looked at anything. He's giving you a sort of a general feel of what that property's worth. The reason why the appraisals are so important is that in all the issues subsequent to a sale, the decisions, are really battles between appraisal evidence. That's the guts of the case. And if you haven't got that appraisal evidence, you're a goner. This business of calling up the agent and saying what's it worth and we'll take our chances and put it on the market. If the mortgagor comes in later with higher appraisals, and you've got difficulty in establishing that was the value at the time of the sale, and I'll get on later as to how that establishes good faith. So anyways, get the appraisals. They're worth it. In an ordinary case, maybe one good appraisal plus one good letter of opinion. Definitely somebody who's not connected with the mortgagee. Independent. It's worth its weight in gold. First of all, it gives you a fair reading as to how to set a reserve price in an auction. It gives you a fair reading as to how to set an asking price in a multiple listing. If you the question of conflicting appraisals. I've heard it, we get appraisals are miles apart. Well, my discussion with the AACIs and the members of the Appraisal Institute have confirmed again and again that there should not be a significant difference between good appraisals of the same property, given the same instructions, given the same investigation. It shouldn't be. If there is, then one appraiser has made an assumption that the other one hasn't, or has looked at different comparables and has not put its mind to it. So when you get an appraisal that's 100% different than another one, or even 50%, 25%, you got to pin those guys down and say, how come? They shouldn't be that far apart. Where you get these big differences in appraisals is in poor appraisal evidence, or in the realtors giving opinions of value without the specific framework of a forced sale with all the details of the property. I've indicated three things you can do. You can call up both appraisers, or the three of them, say, here's the other one. What do you say? Why are you so different? You can go to a third appraiser and say, here are the two appraisals I've got. Will you analyze them for me and tell me why they're different? And he'll point out and maybe go to the other appraisers and say, look, you didn't consider that, you did consider this. And get them to reconsider their opinions. They've missed something. A third way is the Appraisal Institute of Canada actually has a disciplinary procedure on their own where they say appraisers shouldn't be that far apart, and if they are far apart, we're going to call them up. It's very much like a law society disciplinary commission, hearing. Well, they say, now it doesn't necessarily help you to arbitrate your appraiser, but it might result in that. So what I'm saying is that I think appraisal evidence is should reasonably give you a fair report to enable you to act properly in exposing the property for sale. And it's not just window dressing, and it shouldn't be. All right, let's get to the guts of the conduct of the sale. There are not that many cases. So if you really wanted to inform yourself as to the conduct of the sale, you could perhaps read virtually most of the jurisprudence on the subject, and I think I've quoted them in there. The difficulty with the cases, and I'll give you this sort of insight into them. At least this is the insight that I've sort of generated, is that the facts of the case, of each of these cases, are ones that I don't think any of us would have any difficulty with. It's just that the judges have used them as springboards to start discussing almost gratuitously what they think the mortgagee's conduct should be. And you get these, what turns out to be very large obiters that have now sort of start to be adopted. And you've really, well, for example, the Kennedy versus de Trafford is the first case I mentioned. That's the one that everyone usually quotes. A lot of discussion. And a lot of discussion about it. It's been the sort of statement of principle that's usually quoted. But look at what the Court of Appeal in England said when dealing with it. "More lords, I confess I think this is as hopeless an appeal as ever been presented to your lordships." Now, if that ever came to an Ontario Court of Appeal, they'd just say, "Appeal dismissed without reasons." It wouldn't be necessary. But Kennedy and Trafford, English Court of Appeal, waxed eloquently about the conduct of the sale in a case where it really wasn't a big issue. What Kennedy and de Trafford said and what the cases following it said was that the mortgagee and there's a lot of language. That's why I quoted some of these paragraphs. There's a lot of language, and it's loose language, and it's given us the difficulty with what is the standard. You get language like this: willful, he must not act willfully negligent, or negligently, or improvidently, or without want, due care and diligence, in the lack of good faith, acting fraudulently or willfully or recklessly in such manner that the interests of the mortgagor are satisfied. That kind of language has implied what is a subjective test. As long as the mortgagee is being a good guy, if he sells it and it happens to be a low price, he's not accountable for that low price. He was acting in good faith. And the good faith aspect is the subjective sort of test. Interestingly, just not too far off from the decision of Kennedy and de Trafford, there was the McEwen Union Bank case, which was an appeal from the Supreme Court of Canada going to the Privy Council. And they approved what a statement made in the Supreme Court of Canada, saying that, and here's the statement: "It is well settled law that it is the duty of the mortgagee when realizing the mortgage property by sale to behave in conducting such realization as a reasonable man would behave in the realization of his own property." Now, that's a much different standard. That's the standard of the objective test of the reasonable man. And you get that objective viewpoint from McEwen Union Bank saying how a reasonable man would behave in the realization of his own property, reasonable precaution to obtain a proper price in a prudent, business-like manner. So you got those. Now, McEwen Union Bank got tucked away and really wasn't considered because it dealt with a chattel mortgage. It dealt with the care of horses prior to their sale, and whether that statement was said in the context of really not dealing with the sale, but dealing with behaving with the property before you sold it, as to what you could deduct. So that the statement was buried for a while. In Canada, and when you talk about negligence of care of the property and so on, that's always been the case, that the mortgagee would be liable for negligence if he did something wrong with the property. That allowed it to deteriorate or didn't manage it properly. And that is in the old case of Tomlin and Luce. That actually occurred where the auctioneers misrepresented the property in the sale. They said it was completely curbed and guttered, and it wasn't. And the purchaser was given an allowance on closing for the diminution in price that would reflect the lack of curbing of the property. And the court said that was proper to close the sale and give the purchaser an allowance, but the mortgagee was held liable to the mortgagor for that allowance. In other words, he couldn't charge it against the mortgagor. He had to give credit for the allowance given and the property, the diminution in value. In Canada, as I say, a very interesting Court of Appeal decision in the British Columbia. I just mentioned it. It's that J&W Investments in Black. Again, a chattel mortgage situation, but the BC Court of Appeal really went through all this jurisprudence and said it's a subjective test. Unless the mortgagee really does something in bad faith or really does something wrong, he won't be charged with an undervalue. You do everything proper, and you put it up for sale, expose it properly, and get a low price. You've acted in good faith. You're not accountable. They looked at the McHugh quotation about reasonable man, and the BC Court of Appeal said, he set up those words of Lord Moulton. He said, "I do not believe he intended to set up a new and different standard of duty on the mortgagees to that enunciated by the judges in earlier cases. In my respectful opinion, his words must be regarded as having applied only to the limited subject being considered, namely the care and treatment of the mortgage property while in the possession of the mortgagee after seizure." In other words, reasonable man, prudent, objective test dealt with care of the property up to the time of sale, but didn't apply to the conduct of the sale. Then not too long ago, in the 70s, there was decided the Cuckmere Brick case in the Court of Appeal in England. Now that was one, and I think the facts are important for all of us to really consider. What happened there was that you had a bank who had a mortgage on a subdivision of land, and the land was being developed by the subdivider for single-family houses, and all the work had been done for single-family houses. No construction started yet. Default occurred, and the bank starts action to sell under power of sale. They hire very reputable auctioneers, and the property is exposed all over the country, letters to all the people interested in land, widely advertised. And a little before the sale, the auction, somebody discovers that the zoning also covered multifamily, permitted multifamily as well as single family. And they said, well, with the sales all scheduled, let's go ahead with the sale anyways. And they went ahead with the sale, sold it, and then the mortgagor sues. The court says, you should have, it wasn't exposed properly. You should have put in the advertisements that it was zoned for multifamily as well, and there was the good appraisal evidence indicating that had the segment of the population interested in multifamily had known about the sale, the property would have yielded a higher price than a single family. And they awarded damages against the bank for the difference. So, and I must go back, this is happening in Ontario because the case I was telling you earlier about that Arthur Barat and I have on, I won't comment on it except tell you the facts. That's where an institutional mortgagee here in Ontario sells the land, says property for sale, development property for sale, and it was fully zoned. It doesn't say in the ad what it was zoned for, particulars. Exposing the property fully as if you would want to sell it, not just like your pro forma, just putting up an ad for sale, but how does a reasonable vendor actually sell? On that, if I compare that case to the Cuckmere Brick, maybe we're going to succeed, but we'll see what happens in Ontario. Now again, it comes down to Ontario and the Wood versus Bank of Nova Scotia case, which was heard, what, 1979 is it now, Wayne? 80? So we have Ontario now faced with the question. The facts, bank has a mortgage on a property, duplex, I think something like that. They want to sell it, issue notice of sale, expires. They ask some agent for a quick opinion. In fact, they get an informal listing with a friendly agent and tell them, we want to sell it. What do you think it's worth? He says $54,000. And then the agent brings in a friend although it wasn't really approved that there was any relationship. There was suspicion that there was some. It was a woman friend, as a matter of fact, and there was some suspicion of, but it wasn't established, and the court didn't pay attention to it, but it was there. This friend buys it, puts in an offer for $45,000. The bank accepts it. Okay? Very quickly. Well, at the subsequent trial, the mortgagor has appraisal evidence of $95,000, $65,000. So you have, and it's not good appraisal evidence. And Mr. Justice, I think it's Everly, said, I'm really not happy with all these appraisals. They aren't very good. Some of them are just opinions and so on. But he comes down and says, I think the value of the property was $65,000, and he awarded $20,000 damages against the bank. So, and he reviews all this authority, and he tends to come down in favor of the Cuckmere brick, saying you've got to obtain a reasonable price and act in a reasonable way. It goes to the Court of Appeal, and our Court of Appeal, I've quoted in full the judgment of the Court of Appeal of Ontario as it dealt with that point just last year, and it said, we're not going to tell you right now which test. It's not necessary because the bank failed to meet either test. So we don't feel necessary to make a pronouncement. So we're left now saying, what's it going to be? Now, interestingly, since that decision, the Newfoundland Supreme Court reviewed these cases. It didn't have a chance. Bank of Nova Scotia wasn't quoted to him, nor was the BC case. But he reviewed these decisions and gave a synopsis, which is there for you to read. And he says, no, there is not two tests. There's one test. It's good faith. It all boils down to good faith. And good faith has to do with trying to get a good price, too. That if you don't get a good price, you're not acting in good faith. So it's a circular argument almost, that in order to know whether you're getting a good price, you've got to have that appraisal evidence. Then if the price you're getting, and the appraisal evidence has to be based on a forced sale and so on to be realistic for you. And if you have that and a price is offered, then you can get a reading as to whether it falls so below that price that it may be evidence of bad faith. Now, the one thing I can't really come to grips with is that how far below the price will be an appraised price or proper value will be bad faith. Now, again, look at the facts of that Newfoundland case. Again, why would anybody even defend that case? Why would the judge feel necessary to give such a dissertation? There was a $3 million hotel which the mortgagee sold for $123,000 without notice on a 2-day closing. You know, and yet, really, and yet we've got a long written decision on the standard of the conduct, the standard of sale. So we haven't had the factual situation that puts us squarely on, you know, closer to the line. I'm not sure. We have one, superb construction and donor, Mr. Justice Holland, where there stayed a sale. And I don't know what happened with that case. I haven't been able to find out what happened with it, but he stayed a sale where there was an apparent undervalue. And I've given the figures. There was the sale for $950,000, and there was appraisal evidence of $1,059,000 and 2 letters of opinion, ranging from what I say 18% up to a shortfall of 36%, and he felt that that was a sufficient undervalue to stop the sale for the time being and allow it to be exposed to the light of day. Now, all of these cases dealing with undervalue or dealing with bad faith or dealing with undervalue has, and this is what I'm coming to the conclusion that it might be, if I can draw any conclusion, is that if you get a good price, then does it matter what the conduct was? But if you've got a price that falls below value, then you better make sure that the standard has been impeccable, because the cases that are going to peg the mortgagee are ones where you couple bad price with bad conduct, unfair conduct. So if the appraisal evidence, if you can get a price close to your appraisal evidence, or very close to your appraisal evidence, then you don't have to examine. I'm running out of time. You can get a so that the notion, I think, is that your conduct has to be re-examined very carefully if you have a price that falls short, and I don't know how much short, but short, maybe not 10% short, probably okay. 15% short, maybe still okay. When you start getting up to 20 and 25% short, you better start looking at your conduct and see that you've been impeccable. Now, okay, told I got another 5 minutes. Okay, the onus, by the way, is on the mortgagor or subsequent outcomes attacking the sale. And the damages, as I say, is the difference between what he should have received and what he did receive. Not because that's an equitable action for account, not a legal action, as in suits for specific performance, where you go to the date of trial. All right, I'm going to leave conduct of sale for the second and deal, because we're running out of time. The one parting shot, the question of whether you are fine if you give a wide exposure, hold a public auction, and you get a low price. Should you accept it? What do you set the reserve bid at? Do you need to have an appraisal evidence at all if you're exposing it wildly and getting say, open market by auction? I'd be afraid of that because you can't always be sure you've covered all bases. And in order to set a reserve bid, certainly in the Wooden Bank of Nova Scotia, the trial judgment said when the value of the mortgage is low and compared to the value of the debt is low in comparison with the mortgage property. In other words, there's an equity. You owe a duty to get more than just the mortgage debt. You've got a can't, as in the words of Kennedy and Stratford, you can't sacrifice the interests of the mortgagor. So there is some duty to get more and get closer to market value. How close, the standard is still pretty weak. But I recommend reading those decisions. Now, let me go on to one point that I think is, I've only got a couple of minutes. I've listed what I would consider the appropriate things in listing a property for sale. And I leave you to that as to what you should deal with the listing, how you should deal with the listing. In the agreement for sale, I think this is what everybody questions, and we're concerned ourselves in practice. The mortgagee can sell. He's a vendor. He can enter into an ordinary offer to purchase and sell. Period. He doesn't have to say he's a mortgagee. He's a vendor. He has a right to sell if he's given the notice and complied and so on. But there's been a tendency to put in the clauses in an agreement that relate to the power of sale. And they're illusory, some of them, as they now appear in these contracts. Perfect example is the ones I've quoted. Mission Construction. Acceptance by the vendor shall be subject to the rights, if any, of the owner of the property to redemption or to put the vendor's mortgage into good standing. The court said the mortgagor's interest ends at the time the agreement for sale is entered into. Therefore, he had no rights afterwards. So that clause, I don't know what it did. It didn't help the mortgagee and it didn't help the mortgagor. You go on in Green and Royal Trust, it even went further than that and said, it's understood that the property is being sold pursuant to a power of sale, and accordingly this offer is expressly conditional upon the vendor being able to complete such sale, failing which this offer is null and void. And the mortgagor tries to reinstate or redeem prior to closing. The court says no, the rights end. And they say that condition is of no effect. But you get this Nalissa case where the clause went a little farther and said it's conditional upon him redeeming up to the time of closing, and it was communicated to the mortgagor, and the mortgagor knew, and everyone agreed that it was in the intent of that clause to give the mortgagor rights up to the time of closing. The court held, yes, he can redeem up to the time of closing. Now that's very disadvantageous from the purchaser's point of view because he's got an uncertain deal right up to the time of closing. The mortgagee, however, to me, after considering what should be the appropriate thing to do, not disclose it's a power of sale because it might reduce the price, or get the clauses in that'll protect the mortgagee. And on balance, I think you can not show you're a mortgagee in the listing, so that for the public's point of view, it's not a mortgage sale. But when it comes time to the actual agreement, I would cover the interests of the mortgagee by having some protection to get out of that deal in the event there is an offer to redeem or reinstate, or if there's an injunction. The mortgagor may be wrong in that injunction eventually, but if he gets one and the agreement is stayed, you're stuck, as Arthur and Barat are now for over a year on an agreement. If that mortgagee had a clause like that, he would have terminated Arthur's deal and accepted our redemption. But we're all locked in a menage a trois between the mortgagee, the purchaser, and the mortgagor. So there could be an in-between situation where the mortgagee says, look, I'll accept the offer, put in a clause conditional upon allowing me to terminate it within, say, 2 weeks of closing, so that there's at least 2 weeks when the purchaser knows he's got a solid deal. And there's time that the mortgagee has accepted the deal with a conditional, so that he can give the purchaser and mortgagor a copy of the offer and say, here it is, I've sold it. If you've got any complaints, let me know. You can bring an application to enjoin, or you can reinstate or redeem me. And boy, it'll shut everybody up. It'll stop a lot of problems if you've got time to lay it on the table. Am I out?
Very close.
Okay. But if you're going to do that kind of a clause in an agreement, it should be very, very clear and made clear to say it's conditional upon the mortgagor and it's not reinstating or redeeming. Or maybe you only want to be redeemed and not reinstated. Say only upon reinstatement or redemption in full. Give the mortgagor that right, and that clause is intended to benefit the mortgagor. So then he can come in or give the mortgagee the right to accept, the option to accept. But consider the drafting of that clause in the light of those three cases, because it's got to be very express, and just saying that we're selling subject to the power of sale is not good enough. I was asked to mention about selling, whether we take back can you take back a mortgage, and how do you account, and so on. So that was one of the questions that came up, and I'll address myself to that for a moment. If the mortgage provides that you can sell on credit, obviously you can sell and take back a mortgage. Now, most mortgages that say that you can sell for credit say that you only have to account for what the actual cash received. So until that mortgage back is eventually paid off, you're not in a position to account, right? So that if the subsequent encumbrances say, please give us our accounting, you'll say, sorry, wait 5 years. We're not ready to account yet. Now, the question was, what if the mortgage back contains a higher rate of interest, and if you take all that high rate of interest, in the end of 5 years, you'll have a surplus. Well, it'd be nice. If it happens, I think that the mortgage account is taken at the 5-year, at the end of the time when the mortgage is finally paid off. That's the time of accounting, and the interest would run at the old rate, at the mortgage rate, for purpose of the mortgagor, to show what the total amount of accrued interest would be, compounded and so on, giving credit for the monies actually received on the new mortgage all the way along and ending up. If there was a surplus, the mortgagor would get it at the end of 5 years. The other way is to say, and it's never been decided, because if there wasn't such a clause that you could sell on credit, you're deemed, and you do sell on credit, you can do it anyways, then you're deemed to have accepted the credit as cash. It's deemed to be a cash sale. So you account at the time you sell. Now, if you do that, you know, can the mortgagee elect, and this is the answer to the question, and I don't know the answer, can the mortgagee elect to say, I've taken a mortgage back that's going to give me a surplus in 5 years, but I elect to treat it as a cash sale, and I'll accept that mortgage and take the risks under it. Okay? So for purposes of the mortgagor, it's a cash sale, he accounts, there's no surplus. And the mortgagee takes his chances on the attractive mortgage back and gets the higher rate for the 5-year period. That's the answer to that question as I can see it. Thank you.